Ladies and gentlemen, gentlemen and ladies, ladies and gents, we got a little bit of talking we're going to do this afternoon. Let all of you guys know a little bit about what's going on. The issue is, and I'm at a Starbucks, I'm sitting outside enjoying the sun, not on me, in the shade, chilling, cooling, maxing, taxing, and relaxing, and all of that other junk that they used to say. Um, We had a hearing this morning, and I did a video earlier, but I'm going to tape over that video and do this one to let you guys know what's going on. Back in December of last year, they came to the house, decided they were going to arrest, and decided that they were going to caused me problems. Ladies and gentlemen, as I said to everybody, I'd been anticipating and knowing that they were going to do this because they were upset because I filed a complaint and charged them with discrimination, racial, religious, every form of discrimination, age, sex, whatever discrimination there is out there, I charged them with it. They decided that they were going to show me who holds the cards. And so I had time to set them up because I knew that they were going to do what they did. I had anticipated it because this is how they operate. They always retaliate. So how do you take care of someone who always retaliates? Well, you anticipate their retaliation. And so in anticipating that they would retaliate, the very first thing I did was work through in my head everything that would happen from the moment they first decided that they were going to attempt to try to arrest, to the incarceration, to the not giving fingerprints, not giving photo, knowing that if I didn't do that, they were going to retaliate and get angry and, do all kind of stupid stuff. The idea was to have it documented. Then, of course, you bring all these issues up to the court and you know the court's going to ignore you. I anticipated that. I knew that they would do it, and I wasn't caring about whether or not they would or would not ignore. Uh-oh. We're going to move this down because I forgot about that. We don't need it up right now anyway. Um, Knowing that they would do that. So what happens is the first thing when you tell somebody they better do something or they have to do something or you need them to do something, the first thing they do is they try to fight you. They try to say, no, we're not going to do it. Well, that's what they did. I anticipated that they would do that because that's what I do. My job is to think everything out, think every aspect. I have to think what the judge is going to say, the prosecutor is going to say, the officer is going to say, the sergeant is going to say, the supervisor is going to say. I have to think about what everybody is going to say. That's what the majority of the thinking is all about, is sitting up here anticipating and thinking, how are they going to respond to this? How are they going to respond to that? So in each case, outthinking them is what's necessary. So I've been setting them up from day one, getting things on the record purposely. In California, they have a rule. That rule is you have the right to challenge a judge's seating in your case. It's known as a preemptory challenge. You can only do a preemptory challenge once per case. It has to be done, well, technically they claim it has to be done 10 days after this and 5 days after that, and usually that time you don't even know how the judge is. You only had one hearing. So instead of making it after the 5th hearing, after the 12th hearing, after the 13th hearing, but before the jury selection, all that, they say you have to do it within certain days. We know that when they schedule court dates, they do it 2 weeks out, 3 months out, 2 months out, 4 months out. So they put the code in there to limit a person. You can't really prove someone is biased towards you until they demonstrate a propensity and a successive attempt to be biased. So I am challenging their interpretation of that clause in there that's designed to make it look like you have a protection and you don't have a protection at the same time. Well, here's what the clause allows. It says that it has to be before the selection of a jury. You cannot wait until a jury is picked. You cannot wait until a witness has been heard. Now, remember, you get to do a preemptory challenge even at an arraignment. Okay, it will work even then, but the only problem is, this is what you need to know. If you do it at an arraignment, and look, this is the way I think, and I didn't think about this before, but if you do it at an arraignment, then you can also get another preemptory challenge at the next stage. Why? Because you have two arraignments in California. You have the preliminary hearing, which is its own separate case, and then you have, pay attention, the arraignment on the actual charge before the judge after the preliminary hearing. So you never want to waive a preliminary hearing, and in most cases, the attorneys waive your right to a preliminary hearing. You never want to waive a preliminary hearing. Having a preliminary hearing is your way of getting two trials in one case. Okay, and it's also your way of seeing whatever evidence they claim they have. It's also your way of seeing that. So a preliminary hearing, you always ask for that. Well, of course, had the preliminary hearing, they ignored me, ignored everything, because that's what they do. And she claims she found probable cause. What you all don't understand is they've never defined to you what probable cause is. It's this thing about a suspicion or a reason. The reason why they have probable cause is because you testified against yourself by entering a plea. Because you've submitted to the court's jurisdiction, and the court's jurisdiction says that once you enter a plea, you are agreeing that you are more than likely guilty than not guilty. Okay, so that's how they proceed. Okay, now we come to the current day. I waited after I found out about the preemptory challenge and the notice of disqualification. You can actually do a notice to disqualify a judge for cause. You can actually do such a thing. It's under California Code of Civil Procedure 170.1, and preemptory challenge is 170.6. So CCP 170.1, CCP 170.6. You might as well read 170.1 through 170.9. That's where you're going to get most of your information, but focus on 1 and 6 for now. With the issues in this case, in order to get around the fact that these idiots were going to bring up the fact that something was untimely, and because they were going to use a technicality, I decided to do the motion for disqualification first. I sent it in, and then very shortly thereafter, in the same envelope, I put in the motion for preemptory challenge. Now, the premise and the reasoning being is that if I do the motion for disqualification, they have to hear that one first. If I did it for preemptory, then they would say it was untimely. So we do the motion for disqualification first, and we bring it on what the clause says that you can do disqualifying. And it's any reason you have for believing the judge is going to be unbiased. Now, they want to stop you from saying for any reason. They want to sit up there and let you bring up a reason and let you not articulate it in their legal format. Okay? So you just have to specify why you believe the judge is biased. And it can't be just based on what the judge has said. It has to be based on their actions towards you, whether or not they are denying you a right. So that's what you want to put down. Well, anyway, let's get back to the preemptory challenge aspect of things. By putting in the motion for disqualification of judge first, and that gets denied, that puts a stay on whether or not you can do a preemptory challenge. Now, a preemptory challenge, sorry, I got a diesel truck pulling by. It'll be 1 second while he gets his piece of junk out of the way. Motion for preemptory challenge is that one-time only motion, and when it's done correctly, and the rules do say that yes, under certain circumstances you can do it after the statute of limitation of the 10 days, 15 days. You can even do such a motion after a jury has been selected under certain circumstances. And so we do one first, 1 second. Now in California, if you receive a permanent assignment or what's called an all-purpose assignment, you cannot do a preemptory challenge beyond 10 days. Okay, well, here's the thing. Those of you in California, they never send you a notice of all-purpose assignment. They have to send you a notice. They can't just say, well, this case is being assigned to such and such for all purposes. That's what they normally do. But the only way they can do that and not give you notice is if you waive your right to notice. That's why you say, you hear attorneys say all the time, Your Honor, we waive notice. No, we don't waive no notice. We don't waive nothing. Follow the book. There's the book right there. Follow it. Do everything it says you need to do. You do it. But I never waive anything. I even make sure they understand I don't waive a single right. By not waiving anything, you get to now go and say, well, no, you never notified me of the all-purpose assignment. I don't know your rules. And if you're going to have such a rule, you're going to have to provide proof that you've notified me. And you can't just say because you said it on the record. That's not good enough. It wasn't good enough last year. It's not going to be good enough next year. You can't just say it on a so-called record. You have to notify the party. They'll go by what the stenographer says this, the stenographer says that. Do you know, I am looking at they sent a copy of a set of transcripts. There are a lot of things I said that are not there. A lot of the things I said that are not there. Lord have mercy. So from now on, we're gonna be recording things, and I'm gonna let them know because I'm not having that no more. And they ain't no right to a stenographer. That's their junk. They created that. So it's time to get some things changed. Okay, now what's going on is everybody, you need to know that I got this. I'm not concerned about them. My job is to show up their system. My job is to prove what I've been saying all this time. My job is to prove that everything is commercial. And I can do that. I can do that without bringing up this and bringing up that and making it sound like I don't know what I'm talking about, or I'm out of my mind, or I'm kooky, or anything like that. I can prove that their stupid policy of everything being commercial, that gives you the right to do so many other things. But it's the entering of a plea that's the biggest issue. That's the thing you want to stay away from. Okay, let's get back to the nature of this video and why it's being done. Ladies and gentlemen, my number one rule is to use their stupid system against them. Most of you, when you go through this stuff, when you're dealing with this stuff, what you don't normally do is you don't anticipate what they're going to say, what they're going to do. If you can anticipate what they're going to say, what they're going to do, you have to figure out a way of getting them to do things and say things that works in your favor. Okay, that's where your benefit comes from. You have to do things or say things that works in your favor to get them to do things and say things that work in your favor. So I knew the more I asked for something, the more they would deny, the more that they would try to stop me from having it. And so that's why I kept asking for things I knew I had a right to, such as medical, such as a Bible. I asked for things specifically that I knew I had a right to, such as my glasses, such as the right to practice religion as I choose. And they denied every single one. And the medical was the easiest one. All I had to do was tell them exactly what all the symptoms were. They're upset because I put on the record my medical disability. As a matter of fact, the clerk was asking, "Are you sure you want to put this on the record to be visible to everybody?" You better believe I want it to be visible to everybody. There's nothing they can do about it. So what's happening now is I did the motion for disqualification, motion for a preemptory challenge, and the judge doesn't like it. She wants to strike it. It's too late. It is too late. And the reason why it's too late for them to do anything about it is because she had to recuse herself. Now she's going to try to fight recusing herself. She's going to claim that I didn't bring up enough issues. Let me make sure you guys understand something. You don't have to bring up every issue. The code does not require you to bring up every issue. It does not require you to state a legal foundation for your doing this and a legal foundation for your doing that. This is what the case law says. The case law says you must jump through this hoop and jump through that hoop. The actual code doesn't say that. And they cannot prove that it was congressional intent or legislative intent that you do that. Ladies and gentlemen, the information and what you need to know that's going on is they're playing games and I'm playing back. But everything is going according to my plan, not theirs. Everything that they've been doing, I anticipated in advance. And so now it's maneuvering them to get what I want. And so now they're pretty much stuck with giving me what I've asked for. Now, mind you, I'm doing this video and they're going to pay attention to it and they're going to think that they can preempt me in the future. They cannot. They do not have the capacity for outthinking me along this line. Okay, this will be the first of 3 videos being put up today. The next one will be on the Q-Pack, and we'll be letting you guys know about the Q-Pack. And the final one will be letting you know about the Congressional Act, how you can use that to your benefit. I'm going to go in Starbucks and sit down and put my computer back on the charger, and then we'll take care of everything else that needs to be taken care of today. And then I'm going to finally get up from here and walk myself on home. So I'll be leaving here at about 5, so we got 2 hours for me to sit here and do this. So for those of you who are keeping up with things, do not worry about this. I'm allowing this to happen because if I don't allow it to happen, I cannot help over 750,000 people. That's what this whole issue is all about. And some of you will be helped by it as well. So I am doing this on purpose. This was a plan. The moment they decided that they wanted to come my way is the moment I decided I wanted to give them an opportunity. Okay, you got to give the people what they want. Okay, you got to make them clap to this. Okay, it's just the way it is. So, if you understand what I'm talking about, wave your hands. Okay. I think that was about it. I think what was happening today is that somebody had to eat crow. We went to a hearing today, and we went to one yesterday, and that's when I gave them the paperwork, because what they were deciding to do is that they were just going to railroad things. They were just going to control things. They were going to come up with a reason for postponing things. And before they could do that, because the issue was going to be, they were going to say that we want to do another competency hearing. No, you ain't doing nothing. Well, the law says, the law doesn't say that at all. Well, the rules advise me and admonishes. I said, I don't give a what they admonish and advise you. We ain't doing it. It's been asked and answered. You don't get to bring that up now. In a lot of cases, the judge wants to come back at you and tell you about, they want to make sure you're competent and understand what you're doing. I don't need you to make sure of nothing. This ain't your choice. You don't get to decide this. This is my choice. Oh, and by the way, the fact that we get to send them bye-bye takes care of the issue of competency. So that was yesterday, that they wanted to change the subject. They wanted to try to come up with a delay because they weren't ready. The other side already said that they were going to be in court all week, so they couldn't go with the trial this week. I demanded that they move forward. They decided not to move forward and then wanted to change the script. So now I get to go after them and get their attention, which is exactly what I'm getting ready to do. Then the other issue was, she wanted to err on the side of caution. She told me that she was not going to allow me to challenge her and was not going to allow me to disqualify her. Oh well, today she talked about having no other choice. And so now it's time to respond to her bull and take care of her choices. So that's what we're doing right now. No, I'm not afraid. I'm not running from nobody. I am a servant of the true God Jehovah. I tell everybody that the God I serve calls himself the true God, the living God. He's the only one who does that. Go ahead. Every other religion out there that serves a God, go ahead and see that their God does never, ever, ever in the history of their religion claim to be a living God, claim to be the only true God. Go ahead and check. Even the Trinity God doesn't claim to be the only true God. As a matter of fact, the Trinity can't claim to be the only true God, because the Trinity is three gods in one. So they can't even claim to be the only true God. But the God that I serve can hold title to the title, the only true God, which is why I serve him, because he deserves that type of credit. Okay, so because I put my trust and confidence in him, because I am not anxious over anything. Why? Because he's the one who takes care of the anxiety. I'm not concerned about them. Every single tactic they come up with, I will counter their tactic, because that's my job. My job is to outthink them, because I'm very good at outthinking them. My job is to cut them off at the path before they can cut me off. And your job would be to understand the arena you're in when you go into those rooms. Understand whom you're dealing with. They are not smart. They may know a little bit about their procedures and their tactics and their tricks, but even a dog knows more about tricks than you do, because they practice those little tricks all the time. That's why they get better. So don't worry about the idiots and their games. You have to have your own game. So let me tell you, the moment they were indicating they were going to do this, I manipulated them. I had to control them. I had to control the narrative. Why? Because I had to give them a direction. I told everybody, and I tell you to this day, I have not broken anybody's stupid laws, not even their statutory laws. The so-called charge that they want to charge me with says that only the Attorney General can determine whether or not it applies to me. Well, they're presuming that he did say that. But I have a contract that I carry with me, and I have the contract sitting right here, where the Attorney General has agreed that it does not apply. Just that simple. It is just that simple. So because the Attorney General has said it doesn't apply, the judge cannot overrule the Attorney General. Doesn't have the power. She cannot act as the Attorney General or representative for the United States and or for the state of California. She has to shut up, go back, put her thumb in her mouth, and wimp and weeper to someone else. This is my game. I was the very first person to bring forth the challenge in the same type of situation. That's why I had to get the arbitration taken care of as far as myself first before I did it for the rest of you. All right, now we are going to be talking about in a video later today about the Arbitration Act and about how and who and when and why it applies. I will make this one quick reference because some of you are facing foreclosure and you're wondering what do we do because we can't get an arbitration and we got foreclosure. You have to bring a lawsuit. You have to document the fact that you have a contract and has an arbitration clause, and you have to do a motion to compel arbitration. Those are the earlier videos we talked about, but we have people asking these questions. Okay? Right now, SAA is up to speed. It's gotten caught up with notifying everybody. Everybody should have either received or is on the verge of receiving notification of when their hearings are. There were two people, pay attention, there were two people who misunderstood the arbitration, thought they were able to get 5 arbitrations for the price of one. Only now they understand the correctness of it and they've apologized. We weren't accusing them of trying to get over on us. I was just expressing everybody the amount of depth we go through to make sure that we are keeping our word to people, because if we had gone to the site and if it was ambiguous, meaning if it was unclear, then we would have honored the 5 arbitration thing. If the site said it, we would have had no choice because that's what the law requires. It's not about the money that you all are spending. That's not the issue. Because literally, I promise you, we could care less. But we cannot operate as a corporation within America and not charge a fee. You got these companies that go out there and they claim they do stuff for free. They don't do nothing for free. Okay, you got these nonprofit organizations. Do you know that UNICEF is a nonprofit organization? You see how much money they spend and waste every year? We're not even going to talk about the Red Cross, a nonprofit organization. Look how wealthy that organization is. Don't think that all their money comes from donations, please. That's why their CEOs and all of that get paid hundreds of millions of dollars over a course of years. Why? Because they get to play with the tax game. Let's do this real quick, and then I'm going to cut this video off, but we're going to go here. Now this may open up. What we're going to do is we're going to go, is it Apple? Give me a second. Yeah. No, we can go Amazon, sorry. I apologize. Amazon, and what we got for Amazon, 2018. I just put in Amazon no taxes 2018. Now let's ask the question: did Amazon? Oh, it said 1018. Let's get that 1 out of there and put the 2. Thought for sure I put 2. Okay. How much taxes do you guys think? Look, I'm connected, and I know I'm connected. So let me copy. Or I may have to put you guys on pause so that I can get there. Let's see. Yeah. Let's see. I may or may not be connected, so I'll have to see in a second. So 1 second. 1 second. Now this is just Amazon. Apple's going to be the same. But Amazon made, what, $11 billion? No, $111 billion. Sorry. Amazon made $111 billion in profit. And they paid no taxes. How is it possible for them to make $100 billion in profit and pay no taxes? That's Amazon for you. That's how the system works. Well, let me explain to you. Things are not different. Every corporation out there gets to do the same thing. But here's the thing. You cannot do that and not help the economy. That's why, if you guys don't understand, we are here to help government. Uh-oh, it's not letting me connect to the internet. I know why. So let me pause you guys for just a quick. No, I'll explain it on the arbitration video. Forget that. I'll get this video up to you guys in a second, but I'll explain everything on the arbitration video. Gotta let you guys go. Have a good day. Have a good night. Have a good time. Have a good life. Have a good bye. Adios. Arrivederci. Sayonara. You know what I'm saying. Goodbye.